So again, thanks for joining us. We are going to sort of intercede with each other. This is the rough plan that Adrian and I will work through. Just some introductory comments about intellectual property and how we view intellectual property. We're going to highlight some of the key IP management principles, and I guess the nexus of an IP framework that organisations should think about having. We will delve into a couple of issues within the IP management framework in a little bit of quick detail, and then some Q&A at the end. So not a whole lot of time, but hopefully we can leave you with some high-level information and get you thinking about IP, and in particular IP management within your organisation and what you can be doing to bolster that. So I guess the first slide is just our reminder slide about why we bother with this IP stuff. And people who've heard me speak before, these are my classic sort of soapbox items. Most people these days are aware that IP is a significant item of capital, a significant asset for a business. The message I like to share as well is that IP, and in particular formal IP rights, are not just all about a tool that you can, go and whack someone with or sue someone with. They do give you that option, but more often than not, they provide advantages to businesses in other ways. And some of these are listed up on the screen. Whether it's just keeping competitors at bay by having, monopoly rights that are communicated out to your technical area or to your industry sector, whether it's establishing confidence with investors so they're more likely to throw money at you rather than alternatives. The ability to promote yourself, to your potential customer base, supplier base, bargaining power, often when you're working with other organisations, and just generally minimising risk to your organisation. They're all the types of things that can add value to a business. And again, you can see that all of those don't rely on you heading off to court and suing someone, although that is something that IP gives you the benefit of doing. The other quick reminder that we do up front, or that I like to do, is just to highlight that IP to us, and me in particular in my IP management space, is not just that revolutionary or breakthrough invention that someone's come up with. That certainly is a form of IP that can be very important for a business, but all of these other types of IP that you see on this slide can be very important to the success and the longevity of your business. Each of these, needs to be thought of and protected in a certain way. Some of them with formal IP rights, many of them with informal and free, non-costly or no-cost rights. And some of our other presenters, my colleague Mary, who's following up with patents, they're going to highlight some of the differences about how you protect these different rights.
So just to jump in there, Albert, if I can, just to go back one slide, one of the areas I wanted to talk about very briefly, but in a little bit of detail, is data, which is a bit of a hot topic at the moment. So there's no formal, registrable right to protect data. You can't file a trademark for data or file a patent for data. It's typically protected by confidential information, or treated as confidential information, and then kept confidential. And as a result, it's important to make sure that you have the right agreements, NDAs and confidentiality agreements in place to protect data. And not only that, one of the things we see a lot of, and that's come across my desk more recently, is clients who have a new technology, and they're typically in the startup space, and they want to conduct a kind of proof of concept trial. So they have some tech that they want to put on a customer's or a potential customer's site. And then there's the question about who owns the data coming out of that proof of concept trial. And so it's just always important in those kinds of situations that you have some clarity around a few things. Number one, who's got the right to access that data? If your tech is on that site and you don't have physical or remote access to it, you might want to ensure that the other party is going to give you access to that data on a periodic basis. But you also want a right to use it as well. It's one thing to have access, but it's important to make sure that you've got a right to use that data going forward as part of your product development efforts. And then you may even want a right to exploit that data, to sell that data itself. It may have some value in and of itself to others. So those are just a few considerations I flag because it's one of those areas of IP. It's not a traditional form of IP, but it's an emerging area that's getting some attention in the IP space and in particular the IP management space.
Yeah, and we're going to explore some of those themes that Adrian's mentioned there around use and protection a little bit more as we go on. But again, it just highlights that there are different types of IP. Some of them lend themselves to IP rights, formal IP rights, more than others. But there are ways that you can safeguard and lock down information so that you can maintain your advantage over your competitors. I guess these are my 10 soapbox items when I think about an IP management framework. You know, having gone into a number of organisations and rolled out IP strategies and IP policies, these are the themes that come up time and time again. And when I sit back and someone says, what are the most important things we should do if we're going to manage our IP better? I typically land on these bullets. And I'm not going to labour all of them. Adrian and I will explore a couple of them in detail because we find that they often represent how our clients or people coming to us for assistance come unstuck more often than not. But I am just going to mention them very briefly and walk through them. So identification and capture of IP, that's probably my big soapbox item, because without recognising what IP you've got and codifying it, I don't believe there is any discussion about IP management or harnessing the value of your IP assets. You need to know what you're sitting on, and you need to formally record it or capture it somehow or reflect it in an IP register if later down the track you want to extract value from it. You know, things like invention disclosure forms to help you do that. You know, regular meetings where you can have people reporting on new solutions so that they can be captured and recorded in a simple Word table or an Excel document. They're the start of an IP management framework, which I think is, you know, one of the key things you need to be doing. You then need to at least consider what those solutions, what those different forms of IP are, and compare them to one another. You know, which are more important for your business and which need to be protected. And is the protection formal, or is it just something where we just need to lock it down with confidential treatment or encryption? So you need to have those steps of identify, capture, some consideration, evaluation, and then some discussion around protection. Managing ownership and access issues, we're going to come back to. That's going to be one that we'll delve into a bit more. And similarly with the IP landscape and how you monitor and make the most of that. We're going to come back to that in the next two slides. Considering IP more regularly in business activities. This is just one way I found that the companies who do IP management better often get it right. And it's not waiting until the end after a development has been completed and they're just about to go to market to think about the IP piece. But as the R&D is happening, as collaborations are being formed, as activities are happening, what can they do to just be monitoring what's going on in the IP space? And things like technical meetings and gateways and commercial discussions that regularly happen along the line. Often those companies will just have IP in a line item in an agenda so that it's being considered. And rather than wait till the end to find that there's a problem or an opportunity that may have been lost, they're acting on it along the way. That seems to really differentiate the companies that get it right from those that are a little bit more reactive. Making use of free defensive measures. This is things like confidentiality and encryption. Now, Adrian, you might be better saying a couple of words here than me.
Yeah, so to your point, I mean, I think there are a number of things that are free and easy to do within your organization to proactively defend and protect your IP. You've touched on confidentiality agreements, certainly confidentiality notices. So just simply putting the word confidential at the bottom of your slide pack or documents helps put others on notice that this is your confidential information. And similarly with copyright notices, if it's work that you've created or a slide deck or a document that you've created, then you or the company will own copyright in that work. And it's really easy to do, and it can help immensely with enforcement efforts down the track. So when you go to court, often one of the things you need to do is to prove ownership or authorship of your works, of your intellectual property. And if you have those notices there, that puts a presumption in your favor that you are the owner. So it doesn't automatically give you ownership if legally you don't have it, but it puts others on notice that it's yours and helps with that infringement argument down the track. It also cuts off a line of defense. If you get into a situation where you need to take infringement action and you're claiming damages against an infringer, one of the defenses an infringer might have, depending on the kind of IP, is innocent infringement. And they can validly say that they didn't know that you had a patent or a copyright in that work. But if you've got the words patent pending or a patent number on your device, or if you have your copyright notice on your copyright work, then that really cuts off that argument at the knees. So it really helps with your enforcement efforts. And other practical measures you can put into place are things like restricting access to documentation on company servers, encryption for sensitive documents. And I think an important one is also having an exit process for your employees. Very simple to put in place. And so on their way out of the company, it's just important to make sure that they're clear on what their obligations are as far as the company's IP and confidential information is concerned. And, you know, taking that practical step of asking the question whether or not they've destroyed and erased the company's confidential information, because as we become more mobile and remote in terms of our working and our working from home, more company IP is going to be sitting on non-company devices. And this also sets an expectation with your employees, with other employees who are staying behind as well.
Yeah, so the key thing here is that this is just good practice, non-costly in terms of dollars, but obviously it takes a little bit of effort and time. But the sort of things that all organisations can be doing to help safeguard valuable IP, and particularly that stuff that sits in that know-how, trade secret, data, concept, reporty type space, which may not lend itself to formal IP rights. These are the mechanisms that you would typically use to just safeguard that a bit more. So you can make the most of it for your organisation rather than it falling into the hands of a competitor. Item 7 there is a comment about IP champions. So if you're a small business or a sole practice, obviously it's the boss or the manager that, monitoring IP and thinking about IP is going to fall to you. But again, those companies that are a little bit bigger, I find those that nominate a person to be responsible for IP matters and give the others in the organisation a go-to point for queries or some basic knowledge, they tend to separate themselves from those that attack it a little bit more haphazardly. Respecting third-party IP rights, to me, if you're going to bother to capture, protect your IP and want external forces and parties to respect your IP rights, it's incumbent on you in the same way to respect other people's IP rights. Just good practice, but in doing so, you become more IP aware yourself. So it sort of feeds your knowledge base. And look, good practice because you don't want to fall foul of someone else's rights and start getting nasty letters or demands telling you to cease and desist your activities. Never good for a business, never good for a business manager or a director to have to deal with those. Enforcing rights when required. Again, this is not about rushing off to the court and suing someone. Whilst that is a form of enforcement, there are other ways that you can enforce your rights or alert people to what you've got that will put you in a better position. And from time to time, you have to, make people aware that they've done something wrong, breach confidentiality, and there are ways you can do that. And Adrian, you might quickly be able to elaborate on some of those.
Yeah, so I mean, it usually starts with a letter, a cease and desist letter, or depending on its tone, a nasty letter. And the point is with IP rights, it's to make sure that you're taking action as at the earliest possible opportunity, even if it's just to put somebody on notice. So you don't need to necessarily go down to rush. You don't need to necessarily rush down to court straight away, although that may be necessary in some cases, like in counterfeiting cases. But the key is to make sure that you proceed swiftly. And the reason for that is that delay in enforcing IP rights can hurt your ability to enforce them later on down the track. And so it can affect your ability to get an urgent order from the court to stop some infringing conduct until a full trial of the matter actually occurs. And that's a common remedy in IP infringement cases. The longer you take to get to that process to ask a court for that urgent relief, the less serious they're going to take you, essentially, because you've rested on your laurels. And if you haven't proceeded with urgency, then the court's not going to necessarily treat it with urgency. And as well, if you take too long, the court can discount your right to damages. So if you do succeed in establishing infringement and you are able to claim some damages or an account of profits, then the court might discount those awards based on your delay. So just some important things to take into account when you are looking at taking action on your rights.
And look, the last one there is be proactive, and you'll see there's an exclamation mark there. Much better to be on the front foot than the back foot. A lot of activities that we undertake for our clients are helping them repair or plug holes or catch up in terms of their IP position or securing some IP rights. Often because it's an afterthought, or often because they've started to do a deal or they're trying to commercialize and found that, oh, someone else has got a position, an IP position, or the company I'm seeking to partner with has got an IP position. What's my IP position? And often at that point, they'll round back, come to us and say, can you help? And look, we certainly can. It's just much better if you've established and protected your IP position as the company grows and moves forward. Being proactive rather than reactive is going to put you on the front foot. And in particular, just avoid risks mounting up for the organisation and avoiding lost opportunities, whether that's in terms of protection options that may have existed for you, or minimising IP walking out the door as people change seats, which is all too common these days. So look, there's sort of 10 highlights, which go to the heart of what an IP management framework should look like. Hopefully some of you are nodding, saying, yep, I know that, or I know 6 of those, and there's a couple I need to look at. Hopefully there's something there which has resonated. Adrian and I just want to delve into 2 of those a little bit deeper, maybe a couple of minutes on each of these, because we get a lot of questions, particularly about IP ownership and access, which has gone sour because some platform activity hasn't happened. And I'm going to talk about the IP landscape and how people often come unstuck when they don't look at that. But Adrian, I'll throw to you on IP ownership and access and let you explore a couple of these a little bit deeper.
Yeah, thanks, Albert. So clients will often come to us and they want to file a patent, for example, file a patent application, or commercialize some software through a licensing arrangement. One of the first questions we have as IP lawyers and IP attorneys is, well, do you own that IP? Do you own that invention? Do you own that software? And it's an important point, because if you don't have ownership, you don't have entitlement, then you don't have a right to that patent or to license that software to others. It's also important for taking action in court. Investors also want to see that you own what you say you own as well. And so the best way to make sure that you own what you've paid for, or that you own what you've invented, is to make sure that's clear in your written agreements that you have with others who have contributed or who may be working on your IP for you. The law certainly fills in the gaps and has some default positions, but they can hinder rather than assist in some cases. So it's always better to have it documented in an agreement. So just by way of example, the Copyright Act in Australia says that employers own the copyrighted works of their employees. Now, this doesn't cover contractors. So if you engage a contractor to create something for the company, in the absence of an agreement, that contractor will own the work that they've created. So it turns some things on their head, and so it's important just to be aware of that. So the goal is not to leave IP ownership to the law to fill in the gaps. It's to really get it clear in your agreements. And just by way of illustration, I'm going to talk about this, what I like to call a dichotomy between an intentional collaboration and an unintentional collaboration. So an intentional collaboration is where a couple of parties get together and they pool their resources, their IP, their funds, and different people might be bringing different things to the table. But the purpose is to work on a particular project to achieve an outcome. And a classic example of an intentional collaboration is a research collaboration. And the parties, because of the nature of the agreement, will turn their minds to IP ownership, because they're both bringing things to the collaboration in some way, shape or form. And there'll be some outputs. And so who will own those outputs? Who will have the right to exploit them? Will always be a common question. The unintentional collaboration is kind of that gotcha collaboration if you're not careful. So let's talk about a concrete example. Let's say you've invented a formula for an adhesive that you're going to get somebody else to manufacture. You engage a manufacturer. During that process, the manufacturer finds that to produce your adhesive at scale, that they're going to need to add a few more chemicals to your adhesive to stop it drying out on the production line. You go off and you create a new product because you're a growing company and you want to incorporate what the manufacturer has done to your first product into your new product. Now what the manufacturer's done might be an improvement of your intellectual property that could have some value to you going forward, but who owns that improvement? And at law, the default position could well be that the manufacturer owns that. And you might have a license back. The law might be kind enough to grant you a license back to use that improvement, but is that for the original product and all improvements to that product? Is it for new products as well? And that's not clear, and that's the kind of stuff that we get to advise upon a lot. But if the agreement was clearer on those sorts of things, like any improvements created by the manufacturer will be owned by you, then again, it puts the matter beyond doubt. So I guess the overall headline here is paying for something, doesn't necessarily mean you get ownership of all the IP that comes out of it.
Yeah, thanks, Adrian. I mean, really, we could explore each of the items on that slide in much greater detail. And by all means, if anyone's got queries, we're able to be contacted. Happy to have a chat after the seminar and going forward. I just want to move on to the IP landscape. And I guess the messaging here is that there is a lot of information in the IP space that often organisations, individuals are not really aware of. Technical people, scientific people are very good at monitoring their space, technology papers, technological literature. But in the IP landscape, you'll often see things much earlier in the piece because of the requirement in the patent system to file a patent application, which is ultimately published, even as an application. You can get to see those often well ahead of products hitting the market. Similarly with trademarks, often well before companies have positioned themselves with their branding and gone to market, they will be experimenting with early brands, and you can see those by monitoring the trademark register. So there's a good opportunity here to have a look what's going on, what's already happened, use that to inform your own activities, to avoid reinventing the wheel and expending resources which might not need to be expended because someone else has traversed that path already. Understanding what already exists in the IP space will give you a better idea of what your IP assets, how they're positioned in terms of, are they incremental improvements or are they those really big steps or revolutionary steps when you're doing that evaluation piece? And also just understanding what third parties, what rights they hold, what you might need to license in, what you might need to avoid if you don't want to have a nasty infringement discussion. All of this stuff can be understood and harnessed for the benefit of your organisation just by monitoring and keeping tabs on what's in the landscape. And there's a lot of free online sites that you can do that through. And there's a number of paid subscription tools that you can use, and obviously organisations that will do this as a service for you. But well worth considering. The number of times that organisations or individuals has come in and said, I've had a look online, I've done a Google search and I found nothing like this, so it must be novel and inventive. And after the meeting, myself and my colleagues have gone on and jumped onto an IP site and found the exact same thing. Too numerous to recount. They really do happen, they're real stories. And the advice here is have a look and use those free sites to your advantage and get ahead of the competitors. This is where we want to be. This is sort of one of our sum up slides. Really we're all about, in terms of my space anyway, IP management and strategy. If we can identify, capture, protect and suitably manage our IP assets, we get something that provides us an advantage. If we only do part of the way, if we only identify but don't bother capturing, we risk that IP walking out the door when someone leaves. If we capture but we don't protect, we risk not having any advantage. How are we going to leverage it if we haven't locked it down, if we haven't encrypted it, if we haven't applied for a formal IP right that we can then use to bargain with someone? So it's really about getting those things right to get the advantage that we want. And if we do that right, we end up being able to commercialize our IP and use some of these different commercialization options that exist. This only becomes possible if you know what you've got, you've protected it, you're managing that IP right. You can then have the licensing discussion. You can then follow the franchising model. You can do an M&A. Adrian, you might like to elaborate on a couple of these very quickly.
Yeah, I might just touch on the licensing one since you just mentioned it. So the licensing model is where you as the IP owner retain ownership, but you give others a limited permission to sell or commercialize that IP. So it may be a piece of software, a patentable invention, some device, a design, or even a trademark. And you can slice and dice the license in various ways. And often a few ways you might do that is you might give a licensee a license in a particular geographical territory over a particular period of time and for a particular field or industry. And it really depends on what your perspective is in terms of how you want to configure the license agreement. So as the licensor, you don't want to give away too much. You want to reserve the right to be able to go off and appoint other licensees to work this IP. And obviously you want a good royalty. You want to be able to keep the licensee accountable for their performance. And if they don't perform, you want to be able to terminate or perhaps even make the exclusive license that you've granted them non-exclusive for a period of time. And you may also want to have some ownership provisions for improvements that are made by the licensee, because they're going to be the ones that are out there commercializing it. They'll be getting feedback from people who are their customers, and so they'll be in a better position to improve your product. As the licensee, very briefly, you want some exclusivity. You want enough time under the license agreement to recoup your investment. You may need to tool up and invest significant amounts in raw materials, so that all needs to be thought of. Obviously, you want to pay a lower royalty. And at the very least, you want a right to use any of the improvements that you make, and perhaps any of the improvements that the licensors got from other licensees. So we often get asked, can you just create a template licensing agreement? And the thing with licenses is that they're very bespoke. It really depends on the technology, your business model, and your commercialization strategy, and also the kind of IP that you're looking at commercializing.
Thanks, Adrian. And yeah, this slide as well, I mean, each of these bullet points here is a discussion in its own right. And if anyone has specific queries, these are the sorts of things that we'd happily chat with you or follow up with offline and after the webinar. I guess our slide that rounds out our presentation is the reminder slide. What IP management strategy, what's your IP policies is the question. And typically businesses have things in place, whether they're policies or practices or insurances that look after their employees, their investments, their buildings, their capital gear, the inventory, the stock that's on the shelves. But hopefully now recognizing that IP is a business asset as important, if not more important than some of those, what's being done to protect that IP asset is a question that I always ask organizations that I work with. That brings us to the end of our formal part. We're right up against time, and I can see that there's a few questions that have been logged in the Q&A section. So I might just cherry pick the ones at the top of the list and give some quick replies on in the time that we've got left. First question that we've got is there an online company IP management tool available for IDFs, reviews, planning, milestones, budgeting, and things of that nature? Look, I guess the answer is there are all sorts of tools out there. Companies like CPA and Decipher have IP management tools that integrate with a business's R&D activities. They come at a cost, and they typically require, an employee to be exclusively their master and to look after them. They have their place. Certainly, if you've got a large IP portfolio and you're a larger business that can deal with that sort of cost, they're worth looking at. But for smaller organizations, there's probably some other things that you can do in that IP capture, IP register space that aren't going to set you back, thousands and thousands of dollars. Look, certainly this is the shameless plug. This is the type of service that my division, IP management strategy, delivers. And I guess keep an eye on us over the coming months, because we are developing a pack for SMEs and startups where a lot of that initial IP management stuff, policy documents, IDFs, that sort of thing, can be provided in one little parcel. So hopefully that gives a bit of an answer there. Just scrolling down. Adrian, probably one for you here quickly. In terms of managing IP ownership, what are the benefits, risks of putting all IP rights into a separate subsidiary company?
So this is a common strategy for companies that are very IP heavy, is to put your IP in one company, and you have another company that's an operating company that has a license to use all of that IP. And it's that operating company that goes out and interfaces with the public, does deals, signs contracts, And so what you're doing effectively is you're exposing that operating company to any potential loss if something goes wrong. And if something does go wrong and that operating company goes into insolvency, the IP assets don't go with it. The IP assets will be in a separate company, that IP holding company. So that's a typical setup. So that's an advantage. You can protect your IP from the claims of creditors in the event of an insolvency. I mean, not so much a con or a risk, but a thing to keep in mind is that there are obviously tax and accounting consequences to take into account when you're, looking at structuring your IP and your affairs in a certain way. So it's always good to get not only legal advice, but also tax and accounting advice on the benefits and risks of that kind of approach.
Thanks, Adrian. And probably one more. There's a couple of questions which have a trade secret element to them. So I'll cherry pick the first one, and hopefully the answer will address the couple of queries that have been logged here. Patents can be expensive to secure and maintain. Can maintaining something as a trade secret provide the same degree of protection for much less cost? Look, trade secrets certainly have their place. Yes, they are much less costly than patents, where you have to go through a process, expend significant dollars, particularly if it's an international strategy. And patents also have a finite life, whereas trade secrets, if able to be managed, supposedly can last forever. The risks with trade secrets are that things like independent discovery and reverse engineering, more importantly, a trade secret doesn't offer you any recourse if someone out in the competitive space reverse engineers your tech. And similarly, if they happen to stumble across it independently, develop themselves, a trade secret doesn't give you any recourse. So for me, it's a horses for courses type assessment when thinking trade secret versus patent or some other formal IP right. If you have the ability to lock down a key bit of information, maybe there's a bit of flow sheet or processing information or an algorithm in the background that you can just not share and it won't be discovered through your commercial activities, trade secret certainly has its place. But often it may sit in a bucket of IP rights where there may be some formal IP rights and some things held as trade secrets. It really is a discussion that you need to have with your patent attorney. More often than not, if what you're releasing is easily reverse engineered or recreated once it's on the market, a trade secret really doesn't have its place. Hopefully that gives a little bit of insight there. And probably got time for one more. Could you mention some of the free websites to check the IP landscape? Yeah, certainly there's lots of them. So basically most national IP offices will have their own search site where you can search the register of that country for patents and trademarks and designs. In Australia, AusPat is the search site for patents, and Atmos is the search site for trademarks. If you type those words into your Google search engine, it'll take you to the search sites where you can do quick searches or more complicated advanced searches. And similarly, the US Patent Office, the European Patent Office, the Chinese Patent Office will all have search sites of some nature that you can tap into. eSpace, literally as it is, E and space as one word, is a really good one because as well as being sort of the main portal for the European Patent Office, it agglomerates a lot of published information from around the world. So you can often see and get information about foreign patents as well as European patents. So it's almost an international patent search. I wouldn't rely on it exclusively, but it does give you a really good idea of what's going on in your space and is a first port of call for me when I do these things. Adrian, you might have a couple of quick comments about other search sites, for example, that ASIC and domain name search sites that people might be able to use?
Yeah, certainly looking at the ASIC Register of Business Names is a good place to see, whether or not somebody has used a brand as a business name. So often a company may not, register its trademark, which it should be, but you can still be tripped up by rights that are on the ASIC Business Names Register. The other point would be, domain names and conducting searches before you go off and register your domain name or your brand as a domain name. you may not find something on ASIC, you may not find something on the Australian Register of Trademarks, but if somebody has a domain name and they're already running a business with that name or that brand on it, it's very similar to yours or identical to yours, and they may have some pre-existing or prior rights that could be that could spell doom for your ability to use the brand. So it's always good to do some of those checks beforehand. A lot of people think, oh, if I registered the business name or I registered the domain name, I should be fine. I got there first, therefore it's mine. But you really need to be thinking about registering the trademark rather than the business name or the domain name first.
And we'll tackle one more as well. And thanks for hanging on to the line and listening, those who are still listening. I'll read this one out. This is a good one. IP rights are often not easy to precisely define, e.g. coverage of patent claims may be ambiguous. Given such ambiguity, the advice to respect third-party IP rights seems to put an undue burden on a company using a technology in a busy patent field. The burden of enforcement is on the patent owner, not on everybody else to respect often ambiguous IP rights. Why not use the technology and force the patent owner to pursue whatever rights he may believe he has? Yeah, look, this is a commercial consideration, and that is certainly an avenue you can take if the particular space you're in is very busy and there's a lot of applications and patents with spurious patent claims that are hard to decipher. You can certainly take the gamble and say, well, I think I'm not infringing. Let's have a crack in the marketplace and see what happens and hope no one comes and gives me a rap across the knuckles. But it is a commercial call that you have to make. And the downside is that if one of those entities with a formal right thinks that you're infringing and comes after you, you then have an issue where you need to, have that difficult discussion and maybe stump up in a court and try and invalidate their patent and show that what you're doing isn't infringing. That is an extremely expensive, costly and timely exercise, and one that is best avoided in my opinion. If you're a director or a manager of a business, funds that would be sapped out of the business, trying to argue your case are probably better spent being invested in your own IP and protecting your own IP. But it is a horses for courses thing. I mean, you guys know your technical sectors better than we do, and you'll know whether it's an active litigation space and people defend their rights furiously or not. But it's a discussion that you should have with your patent attorney or someone like Adrian, an IP lawyer, just to get a feel for what the real risks are. If you're able to monitor and make more cautious calls and say, look, we're keeping an eye on the landscape. We see that there's patent applications being filed that look like they read onto what we're doing, but we're comfortable that these are going to be whittled down, or we're going to keep a watch on them to see if they get whittled down during the patenting examination processes. They're all good practices to help de-risk the situation for you. But at the end of the day, it is a commercial call. You can certainly have a look and have a gamble. The risks of getting it wrong are significant, but not a lot of patents are litigated. So that's something that is in your favour. Adrian, you got anything you'd like to add to that question?
Yeah, no, the other point you mentioned, or one of the things you mentioned, was directors. And if you are a director of a company in Australia, you have directors' duties. And so, one of those is a duty to act in the best interest of the company. And there are multiple others. And you don't want to fall afoul of those duties to the company by being aware of some potential IP infringement issue, and then, pulling the trigger and saying, oh, well, we'll just roll the dice and see what happens. Because that could land you in hot water as far as the Corporations Act and your director's duties are concerned. But it could also make you personally liable as the word is unfortunately a very technical one, but a joint tortfeasor. You could be joined as a party to the action if you are a director and you were knowingly concerned or involved with the infringement. So, I mean, that's obviously at the very other end of the scale, where the director has fixed knowledge or actual knowledge of, what they could be doing is infringing. But it does really heighten your risk. And then, the other point might be is that you have IP infringement insurance, but does your policy respond in certain cases where you have knowledge, but you have nevertheless rolled the dice? And so those are all important questions to be factored into your risk risk balancing exercise when you're making a decision about launching a new product. Certainly risk can be mitigated by, by doing some searches beforehand, and that, they need not be chapter and verse and, searches that traverse every country under the sun, but some really targeted ones to help, mitigate 80% of the risk, thinking about that 80-20 rule.
Yeah. Thanks, Adrian. Yeah, I mean, it's a really good question, and it's multifaceted, and it goes to the heart of that proactive versus reactive behaviour. Just ignoring what's out there and having a crack places you at considerable risk. But if you can de-risk by having a look, understanding and taking calculated gambles, you're going to be better off. And remember, there's technical, there's commercial, there's legal implications, so make sure you get advice on all of those fronts. Look, I'm very conscious of time, and we've gone well over, so thank you for sticking with us, everyone. You'll see our contact details on that final slide there. If you do want to have a chat, feel free to reach out to either myself or Adrian. More than happy to have a chat or a coffee catch-up at some point, particularly when things return back to a greater level of normality. Or ping us an email, and happy to revert and give you whatever insights we can. And I'd also encourage you, my colleague Mary Turanek, in about 20 minutes is about to give one of these IP in Focus presentations on patents. If you've got any queries or issues around patents you'd like to hear a bit more about, that would be well worth joining into. Otherwise, thanks again for joining. I hope we haven't bored you and you've taken away at least one little snippet of information. And I wish you all the very best for the rest of the day. Thanks very much, everyone.
Thanks, everyone.